In this lesson, what we're going to do is do a very brief history of the modern development of international humanitarian law. Because in reality, we could talk about the ways in which law has been regulated for thousands of years. There's been some kind of principle that there exists some kind of rules when it comes to warfare. And of course, this would not constitute international humanitarian law in the same kind of way that IHL today exists. So we're going to focus really beginning with what is traditionally understood as to be the inception of some of these general humanitarian ideas. And we will then also talk about the convergence between the two bodies of international humanitarian law, which are divided into what are described as Hague Law on the one hand and Geneva Law on the other. These two are both realms or aspects of international humanitarian law. They cover slightly different elements of the conduct of hostilities, but for the most part, and at least in recent years, with the addition of the additional protocols to the Geneva Conventions, we've seen a somewhat of a convergence between these two bodies of law. And the traditional historical understanding as to where IHL first begins, or at least IHL in the modern context as we know it today, and subsequently also the International Committee for the Red Cross, that all comes out of the aftermath of the Battle of Solferino. Now, I've already mentioned that we could talk about the ways in which conduct and law has existed to regulate armed conflict. It goes back to ancient times, or at least there are very few sources going back to ancient times that can really give us some indication as to where the armed conflict has been regulated in the past. However, this understanding of IHL as we know it today is, like I've said, something that began really out of the Battle of Solferino. The modern interpretation of IHL comes from the 1859 Battle of Solferino. And it was not necessarily the battle itself, but it was more the aftermath of the Battle of Solferino. Because a Swiss businessman and humanitarian activist by the name of Jean-Henri Dunant came and saw and witnessed the aftermath of the Battle of Solferino, and saw the amount of horrific suffering that was caused as a result of the battle, the injuries and the deaths and the ways in which these individuals were injured and had been killed. And so ultimately, as a result of this, as a result of seeing these horrors in the aftermath of this battle, Dunant would go around and begin to run a campaign that would lead to the creation of the first Geneva Conventions, as well as the establishment of the International Committee for the Red Cross, the ICRC. And this is really, like I said, where we see the beginnings of the modern doctrines of international humanitarian law with the first Geneva Conventions following the end of the Battle of Solferino. And this is really where we see modern international humanitarian law develop, because modern IHL in this context is therefore divided into two main areas of law, both of which spawning out of this humanitarian effort that existed at the end of this particular battle. We have the Law of the Hague and we have Geneva Law, like I've just mentioned. And while there is seemingly an increase in the convergence between these two areas of the law, they do still exist as separate entities to an extent. And the reasons for the difference in nomenclature when it comes to the differences in these two areas of law just comes from the names of the conventions and international conferences from which these rules derive. So Geneva Law, for example, deriving out of the Geneva Conventions, for example. So, really, where we see what we consider to be Hague Law, it draws its origins from the Hague Conventions of 1899 and 1907. And the law of the Hague and Geneva Law both deal with different elements of international humanitarian law. And like I've said, there is somewhat of a convergence. So, for example, the Hague Law, the Hague Conventions, will concern itself with a number of different elements of IHL. So, for example, the definition and scope of combatants in an armed conflict is something that exists as part of the Hague Conventions. The means and methods of warfare, something that we're going to look at in a future lesson as well, is also something that gets its derivation from Hague Law. On the other hand, Geneva Law, which came from the first established Geneva Conventions in 1863, pay closer attention to the protection of those who are unable or unwilling to fight in the process of an armed conflict. So rather than talking about the means and method of warfare, the conduct of hostilities in terms of the definition of combatants, what Geneva Law, the Geneva Conventions, deals with is looking at protecting those who are unwilling or unable to fight in the process of an armed conflict. So, for example, a civilian or somebody who is potentially hors de combat, a sick or a wounded individual, like a soldier. And so, therefore, we have the development of the Geneva Conventions. Now, the next lesson, what we're going to do is talk about the sources of international humanitarian law, and we will draw a lot of attention to the various different treaties and conventions, which, treaty and conventions are exactly the same thing, that derive these different rules. So the Geneva Conventions, their additional protocols, as well as some other conventions relating specifically to the conduct of warfare and conduct of hostilities. And we will also pay close attention to the ways in which international humanitarian law has developed through the development of customary principles as well. So we'll talk about that in the next lesson. But for now, it might be worth noting the basic treaty law that exists for the regulation of armed conflict, specifically within the context of the Geneva Conventions. Now, contrary to popular belief, there's no such thing as a Geneva Convention, singular. They are Geneva Conventions. There are 4. So, in general common parlance or in popular culture, whenever there is a reference to the Geneva Conventions, they are referenced as a singular document like the Geneva Convention, which is not true and is one of these pet peeves of an international lawyer. So, while the Geneva Conventions developed in a number of stages between 1864 and 1949, we have this Second World War, post-Second World War development that really is where we see the modern revisions and the modern interpretations of the Geneva Conventions as they apply to this day. So we can talk about the various different developments and changes that are made between 1864 and 1949, but it is the 1949 Geneva Conventions that are really what are important and what we would reference and cite if you were to write an essay on IHL to this day, for example. And like I've said, there are 4. So the first Geneva Convention is the Geneva Convention for the amelioration of the condition of the wounded and sick in armed forces in the field. This was first adopted in 1864. It was then revised in 1906, 1929, and then the final revision came in 1949 at the end of the Second World War. The second Geneva Convention is the Geneva Convention for the amelioration of the condition of wounded, sick, and shipwrecked members of armed forces at sea. This, again, was adopted in 1906 and then revised in 1949. So you notice that between these 2 Geneva Conventions, the first and the second, we are talking about the amelioration of the condition of wounded and sick members of armed forces, one being on the land, essentially, in the field, and second being at sea. So that's what these 2 conventions do. They both deal with wounded and sick, one in one area of the world and another in another area of the world. The third Geneva Convention is the Geneva Convention relative to the treatment of prisoners of war, first adopted in 1929 and then replaced in 1949. Again, this is dealing with a specific condition that certain soldiers and members of armed forces could potentially be in. The first deals with wounded and sick in the field, second, wounded and sick at sea, the third dealing with those who are members of armed forces who are in detainment, who are now prisoners of war. And then finally, the fourth Geneva Convention is the Geneva Convention relative to the protection of civilian persons in times of war. This is a convention that was adopted in 1949, and so we essentially have the different protections that are created and established in IHL when an armed conflict takes place. We have to protect those who are wounded and sick. We have to do that at both at sea and also in the field. We also want to protect prisoners of war, those who have been detained, and then we also want to protect those who aren't fighting at all, who are not members of armed forces, i.e. the protection of civilians. This is what the 4 Geneva Conventions do. Now, in addition to the Geneva Conventions, we also have the additional protocols, which are also important to be cited. The first additional protocol was established in 1977, and it relates to the protection of victims in international armed conflicts. Now, this is very important and very influential for the adoption of IHL principles, but what is arguably, in my opinion, slightly more important is the second additional protocol, because what this does is it applies the relating to the protection of victims, but not just to international armed conflicts, but specifically to non-international armed conflicts. Now, what we will note is that when we look at the distinction between an international and a non-international armed conflict, you will note that there is a substantive body of law, specifically treaty law, that deals with the regulation of hostilities in the context of an international armed conflicts between states. Whereas when it comes to non-international armed conflicts, there's a lot less treaty law and there's a much heavier reliance on customary international law. So the only real reference in the treaties, or at least in the main aspects of the treaties, are of course Common Article 3 of the Geneva Conventions and Additional Protocol 2 from 1977. So the distinction between international and non-international armed conflicts is still something that is particularly relevant and is very much seen to be the case when we talk about, for example, the ways in which treaties have regulated armed conflicts. And then finally, the least important, in my opinion, of the additional protocols is the 2005 Additional Protocol 3, which just relates to the adoption of an additional distinctive emblem, and is never really referenced in any major textbook or study on international humanitarian law. For the most part, we're talking about AP1 and AP2. So that's essentially the historical development of this particular area of international law. In the next lesson, what we're going to do is talk about, like I said, the sources of international humanitarian law, paying close attention to mainly the law relating to treaties as well as to customary international humanitarian law.